The Erie Institute of Law presents Nationwide Injunctions, Executive Orders, and Impeachment Threats Against Judges. This program was presented live on May 5th, 2025.
The Bar Association of Erie County is committed to defending the rule of law and the independence of the judiciary, and these are, to say the least, interesting times for those concepts. But that means they're a huge opportunity for us as a profession. Today's program is very much aligned with those aims, and I'm very excited to welcome and introduce our speaker, who's a retired federal judge, law professor, the Honorable Paul Grimm. Judge Grimm served on the federal bench for 25 years, first as a magistrate judge and then as a district court judge in the District of Maryland until he retired from that in 2022 and went to Duke Law School, where he serves as the Bolch Judicial Institute director and law professor. He has written and taught extensively in civil procedure, electronic evidence, and discovery, and we are very fortunate to have him with us today. I want to make sure that I recommend to all of you to read, and maybe we'll find a way to share this with the entire group. But if you can, read Judge Grimm's February 11, 2025 letter regarding unwarranted threats and attacks on judges. This is a required reading for everyone in the profession these days. Judge Grimm, thank you for being here.
It's such an honor to be here with all of you. I enjoy very much the opportunity to spend time with lawyers, particularly lawyers in regional groups. It makes me feel like I'm out there with you, and I really appreciate that. I will tell you that with all the speaking I do in these areas, there are only two professions in my mind that give back as much to the community. One is the clergy and the other is the bar, and they have much better press than we do. So I don't know why we don't get the press benefit from that, but lawyers do more to engage with the public, and they're able to help in this particular area that we'll be talking about today. I was repeating my oath that I took when I became a lawyer in Maryland almost 50 years ago, and when I was thinking back about that and what it means to be a lawyer and what you and each of you can do with your communities, it makes me very, very proud of what we are and what we represent, and hopeful that if we all work together, we'll be able to continue to help our public appreciate the founding principles that made this country the one that we would all die for, frankly, and to maintain that we preserve these essential characteristics of what our constitutional democracy is. So it's a pleasure to be with you.
Thank you very much for being here, Judge. If it's all right with you, I'll try to start us off on different topics and based on the materials that you provided. And I want to begin by asking, if we start at the beginning for our topic, what are nationwide injunctions, and where do they arise from in terms of the concept of judicial review?
This is a great question. So we all know that the legal system that we have, originated from two sort of branches. There was law and equity, and they were merged. They've been merged in the United States in the 1930s in the rules of procedure, and in most states they're merged as well. And they have different kinds of relief. And one of the things in civil cases that judges have the ability to do is, upon a request from a party and the proper showing of irreparable injury and a need for an order, either a TRO, temporary restraining order, or a preliminary injunction, or as part of a resolution of a case, a permanent injunction, the ability to issue the extraordinary remedy of an injunction that prohibits a individual, organization, or governmental official from doing action or refraining from doing action. Very well settled, equitable remedy. Extraordinary remedy, lots of criteria before it can be applied, but still well established. What's new about this is the notion that a single district judge, obviously unelected, unaccountable to the public, getting a request for a restraining order or a preliminary injunction in a case in the context of where we've seen it discussed in the last, say, 100 days or so, of a challenge by a litigant who, we keep in mind, Brian, they've got standing, they've got justiciability, they're not dealing with the political problem. It's not a moot issue. So all those Article 3 guardrails have been met. And now you've got an individual or an organization saying this function that has been put in place, this action by the federal government violates my constitutional or statutory rights. Judge, I ask for this remedy. Well, if it's just that one person who says, I had this happen to me, then you could issue an injunction that deals with that one person. But the ones that have created all of the scrutiny and the criticism deal with when you have an organization or a group of organizations that are coming in and asking the judge not just to issue an order enjoining the parties to that particular case, but across the entire country. These types of nationwide injunctions didn't exist in any real consequential fashion until about 1960. And then beginning in 1960, you started to see them pop up. They really increased in terms of frequency and impact, beginning in President Bush's term, where about 14, 15 of them were issued, dealing with White House orders and initiatives. The same happened with President Obama. During the first Trump administration, there were 67 of them issued. And in the first 3 years of the Biden administration, there were about 15. And it's not the numbers alone that have their impact. It's just that there's a new wrinkle that we have in that, look, every judge, every lawyer who is representing a client and going to be involved in court absolutely wants to try to file in the most favorable forum that they can find. That is part of what a good lawyer does on behalf of their client. There's no objection to that. If they didn't do that, then they probably wouldn't be doing their job. But what you have is when you have these lawsuits that involve a broad policy that affects the whole country, is you're going to have nationwide venue. And if you can look to a particular court where there's a single judge with a known track record that you think favors your case and you can file there, you're going to file there. And so what that has created is sort of a overlay for these broad, universal, nationwide injunctions that allow the party that wants to file and get one of these injunctions to cherry pick a venue that they think is likely to get them a judge, or they know will get them a judge if it's a single judge in that venue, who will be favorable to their claim. And this is possible because if you look at various segments, states and the federal bar, you have over 85% of the judges in the Ninth Circuit were appointed by a Democratic president, and you have the opposite in the Fifth Circuit. So by virtue of where you file your case, you increase the possibility that you're going to get a judge who will, based upon their prior rulings or however you assess that, and you lawyers are pretty good about sort of sussing out what you think your chances are with a particular judge, and the internet and internet research has given you even better ways of doing that, to filing there. So it has given this an appearance that, for example, of the 67 injunctions that were issued against President Trump in his first term, 93% were issued by a judge appointed by a Democrat. And when you look at the injunctions that were issued against the Biden administration, 100% were issued by judges appointed by a Republican. This puts a gloss over these procedures in a way that gives them an appearance of political bias and lack of independence, judges that are politicians in robes, even when in many instances the judges who are getting that are doing everything they can not to let whatever their political beliefs are influence what their decision. And it creates this sort of appearance of a political process. So the mechanism by which you're seeing so many of these cases that have led to calls for impeachment or criticism of the judges ruling it in a way that gets beyond what Chief Justice Roberts called informed criticism and gets into threats or intimidation or posting information about their family members or sending anonymous pizzas to them or other things that have been so problematic, is that it's through the crucible of these nationwide injunctions that these orders have been magnified and have caused all this discussion and have led to the attacks and the questions about, what the consequences of that kind of dialogue could be.
So Judge, I want to drill down into some of the things that you've just mentioned. The You mentioned that there's an apparent politicization from the statistics that you mentioned. What's the reality of that, and what is that apparent politicization? What's behind that, and what's really going on with why do those numbers exist if it's not uh, an expression of politics?
Well, I think that when you talk to most judges, it's a fair question. And in fact, with some of the programs we've been doing with education of the public, who don't know a whole lot about our legal system, it seems, that one of the questions they'll ask is, well, if you're at a state and you run for election, oftentimes you're running on a ticket as by affiliated with one party or the other. If you're a federal judge, a president appoints you. They appoint people who are by and large from the party that they have, and that process of selection is inherent, and retention is inherently political. So why shouldn't we think of judges as just politicians in robes? And the answer to that question is, and this is based upon hundreds and hundreds and hundreds of hours and years of interactions with both state and federal judges, is that it's true that the process by which a person becomes a judge involves politics. Sometimes in state politics, it's direct election. Sometimes, like in North Carolina, they run on an affiliation with a particular political party. Sometimes they run, but they don't run with an affiliation. But the run up to it, the parties will talk about, give checklists as to who they think the public should know about. And obviously, in the political arena on federal courts, they're appointed. But we like to say that the process of becoming a judge involves politics, but the art of the process of judging does not. Most judges that I know bend over backwards to avoid um, any way of appearing to be acting other than under the law and the facts. Now, judges have to show their work, of course, right? So when we issue an order, we don't just come out and say, I got up this morning, I've been thinking about this, here's my order. And we lay it out, we talk about the jurisdictional issue, and we talk about the facts, and we apply the law, and we show our work. And if we get it wrong, you can go up to an intermediate appellate court or ultimately up to the Supreme Court. Appellate courts can and have stayed these nationwide injunctions if they think they went too far. And the proof against it being a true assumption that the political party of the president that nominated the judge, will predict the outcome of their ruling, is that some of the judges, Judge Kogenhauer up in Western in Washington, and Judge John Bates, who's one of the most respected trial judges I know, they were both appointed by Republican presidents, and yet they have been accused and vilified and attacked for issuing orders where they did issue an injunction in a case involving a recent policy and laid their cards on the table and explained why. The other thing that would cause you for me to say that the perception that it's always the politics of the party that is responsible for them becoming a judge that governs the outcome. In a recent decision just a couple of weeks ago, Judge J. Harvey Wilkinson, a very highly respected conservative judge on the Fourth Circuit, issued an opinion denying an appeal of the district judge's order in my old court in the case involving the Maryland resident that was erroneously deported to El Salvador, and in which he came out and said, look, the executive is entitled to respect and to deference from the courts, of course, but that's a two-way street. In the case here, in this particular instance, the Supreme Court has said that due process is required. The trial judge is doing their best to implement the Supreme Court's decision, which she's bound to follow. The arguments in this case stand for a proposition that if it were taken to its logical extension, would amount to lawlessness. And to stop this and to interfere with this would be detrimental to it, not just from the perspective of judges, but from every member of the public. Now, that was a respectful decision. It respected the deference that was naturally due to the executive, who has great responsibilities and needs a lot of flexibility, but pointed out that the courts also have an important role here. And so because you are getting decisions from individuals who have been associated with a political party that is the same political party as now is in power, helps us to belie in individual cases and show just how much judges work hard on the facts and the law to try to explain what it is that they're doing and avoid any appearance of politics or politicization. In addition, and this kind of works two ways, Brian, because at least in the federal courts, the ethics rules are very, very, very strict. You cannot talk about any case pending before you or any issue before you or likely to be before you for fear that your comments will be perceived as having predisposed you to a particular outcome or not. And that means that most federal judges, myself included, when we were on the bench, we just wouldn't talk about things. Now, the ethics codes say you can talk about the judicial system or the legal system or our branch of government. You can engage and you're encouraged to do so. But most judges will either just not take the risk of public discussion about what they do, or be very, very, very circumspect and very, very, very narrow in what their comments are. And so they don't have the ability to speak out. The judges who've been attacked cat come out to the public and say, well, wait a minute. Let me tell you, here's why I ruled that way. I said this, this, and this, and you have to understand that these circumstances were there. This is why I did that. They can't do that, but the bar can. Members of the bar can do that. And what we have learned in the work that we've been doing at Duke is that you must be nonpartisan, you must be informative, you must be respectful, you must shed light but not heat. And when you do reach out and engage with the public, they are really they find these to be important issues, and they have good questions, and they really appreciate the opportunity to have someone talk to them, respect their ability to make up their own minds, but help them understand how this process works and why it works the way that it does.
So Judge, as a profession, it seems to me that it's important to us to have ways of understanding and talking about the use of of these nationwide injunctions that are not political, that are not partisan, but at the same time are defending the rule of law, defending the independence of the judiciary. And from what you just said, it sounds like we've got a situation where the ability of the litigants to pick the forum then leads to an apparent political outcomes when maybe that isn't a valid conclusion from that. So if that's a concern, and I guess I'm suggesting that it is, what other concerns are there about nationwide injunctions, the way they're currently used and organized, that we need to be mindful of? And then I think we're going to want to talk about, what do we do about it?
Yeah, Brian, great question. So it's interesting because depending upon you always say, whose ox is getting gored, or what ox is doing the gorging. Um, the when you have a Democratic president who believes that their policies are being restricted by a judge who was appointed by a Republican president and vice versa, then it's the party that thinks that they're being harmed by the injunction that complains. But when it's the other way around, and someone from their party challenges and blocks a policy from the opposing political spectrum, then those nationwide injunctions are not so problematic. The truth of the matter is that the way in which these injunctions are issued many people from both sides of the political spectrum have been complaining about for many years as being problematic. Now, there has been a bill introduced in the House, and it has passed the House. I guess then now it's in the Senate, that would change the way in which these national injunctions are issued. To give a little bit of context, last year, the Judicial Conference of the United States. Now, if you were to look at the United States judiciary, you've got the United States Supreme Court, and you've got the courts of appeal, and then you've got the district courts. And then you also have the Administrative Office of the United States Courts, which administers the courts. And as part of the judiciary, there is sort of, you can think of it as a board of directors of the judiciary, and that's the Judicial Conference of the United States. And it's got representatives from all the circuits and all the districts. And they have committees that deal with almost everything that touches on the administration of the United States courts. And there's a court management, CACM, Court Administration and Court Management Committee, as well as committees of practice and procedure, civil procedure, which is the committee I was on for 6 years, evidence rules, criminal procedure, appellate procedure, bankruptcy procedure. And so you've got various committees that are responsible for updating the rules of civil procedure, the way cases are managed and assigned. And they came out with guidance last year, and they said, we have this appearance of undermining impartiality. And we are recommending that each district and each circuit have policies so that there is random assignment of these cases, so that you can't go and have a preordained just by the filing of a case what judge will get it. And whether that means that you have to randomly assign, and where you have it is you have, my court has 2 divisions, and we have 4 active district judges in one division and 6 in the other. But we got multiple judges in each of our divisions. And if you are assigned a case, it's randomly assigned, and you can't preordain what judge is going to get it. But if you have a district court in some places, and examples would be out in the West and the Middle West, where you have these huge states of gigantic size, and you might have a one judge courthouse. You file in that, if every case filed in that court goes to that judge, that's when you have that appearance where you can preordain who gets it. So the Judicial Conference came out and said, we highly recommend that every circuit and every district come up with ways for these particular types of injunctions that they be randomly assigned, even if you have to assign it to the judge in a different division. And some courts came out. I think the District of Massachusetts did that, and the First Circuit had policies that did that. Other circuits said, no, we're not going to do that. Who are you to tell us what to do? We have the ability to be able to do it ourselves. So there was not uniformity within the judiciary about how to deal with that. In the proposed legislation, what it would do is it would restrict the ability of an individual district judge to issue nationwide injunctions and restrict it to only issuing it to the parties who appeared before the court. That's a fix that when you first look at it, sounds like it'll be a pretty good fix, and maybe it is. But here's the problem. In some of these cases, what you had was 19 attorneys general from 19 different states coming in and saying, hey, our 19 states are affected by this policy. We want an order. And if that happens in 19 states, then roughly 40% of the United States has been covered by that, and you've limited it to the parties in the case. Flip side, you have the same thing if you have states that from all the attorneys general from the Republican states coming in and trying to do that. You're going to have a huge swath of the country, so that the limiting focus, if it's based upon just the parties, might be problematic. Other ways you could do that is you could say that in a case that is and remind you, it's not a nationwide injunction against a corporation or an organization that might do something that affected everybody in the nation. It's when it's being focused on a White House executive order or a policy where the president's been elected and is taking that election to be a mandate to act in a way that they've told the public they will act if they're elected. And they put this stuff into place, and the judge says, time out, you can't do that. That's the focus that raises these issues that we've been talking about. And you could say that you can't have an injunction in that particular type of case unless it's issued by, for example, 3 district judges appointed from different districts, different circuits. You could manage it any way you wanted so that you didn't have a single judge. And we have in voting cases and redistricting cases, we often have 3 judge district court panels. So there's a lot of existing precedent for that.
Mhm.
If you did that where you had to have a judge from, 3 judges from different jurisdictions, that would happen. Sometimes I've heard proposals that you should allow them only to be made at the circuit court level, not the trial court level. There's a lot of different ways that you could go about trying to do that, but what it would require is some thought as to just how you should tailor the system to not prohibit nationwide injunctions, because there are times when they're frankly essential. But on the other hand, regulate them so that you can minimize these forces that give the appearance, even if not the actuality, of political bias in the way in which these injunctions are issued. So there's work that could be done there. The House has come up with one proposal. We'll see what happens in the Senate. And that may or may not be implemented. And then we'll see. But there have been calls from both sides of the political spectrum to amend this process for quite some time. Perhaps now there is that initiative. And of course, Congress has the authority to define the jurisdictions of the lower courts, right? Not the Supreme Court, because that's given by Article 3. But they can do that. And so they have the ability to take a look at that. And you would hope that, if you could get bipartisan support for some modifications to that, it would go a long way for helping to sort of remove what I would call the flashpoint, Brian, where these orders have led to the attacks, personal attacks on the integrity of the judges, attacks on them in social media, displaying information about their families, their personal location, where their children are, demands that they be punished, that they be impeached. And Reuters came out with an article last week. If you take a look at that, if you're interested in this, I would encourage you to take a look at it, where they actually had clips from some of these emails that were sent to judges and some of these voicemails that were left. They're chilling. One of them was basically saying that the children of the daughter of a judge should be sexually assaulted, and that a gang member should visit the judge and his family, and commit violent acts against him so that they quote unquote died laughing. This kind of call, there's no way that you can justify this kind of an attack. They're cowardly. They're designed to intimidate, and there's no place in our constitutional structure for them, and they need to be called out for what they are, which is just repugnant and beyond the ability to be rationalized or supported. And I will tell you, perhaps a topic that maybe jumps ahead, Brian, and if it does, we can pause and go back to it later if you wish.
That's fine.
But Chief Justice John Roberts in the last 6 months has twice addressed this issue, which is fairly extraordinary. In his year-end report for 2024, he gives a year-end report of the federal judiciary every year, every December, and he devoted almost the entire report last year, 2024, to talking about acknowledging that people can disagree with court decisions. They have a First Amendment to do so, and an informed criticism is perfectly fine. But he identified 4 kinds of things that are inappropriate, that cross the line, and they undermine the rule of law and the protections of our constitutional system. One is threats against judges. 2 are attempts to intimidate judges. 3 would be arguing that judges should be impeached merely because you disagree with the decision that they issued in a case, which has never before happened in this country's history. And number 4, calls to disobey a final ruling of a court, to just ignore it or disobey with. And those 4 kinds of activities, the Chief Justice said, are beyond any legitimate support for being an appropriate way to deal with a disagreement of the court. And then later, just about a month or 2 months ago, in the face of all these demands for impeachment of federal judges, merely because people disagreed with their rulings, he issued a very short but very powerful statement, said, in the history of this country, there has never been a justified reason for impeaching a district judge or a federal judge simply because you disagree with their ruling. So twice in the course of 6 months, the Chief Justice has come out to address this issue. He has never before felt a need to do that. And the fact that he has done it twice in the last 6 months, I think you can draw some inferences from that in terms of what's going on today.
Judge, earlier this afternoon, you mentioned how the use of nationwide injunctions seems to be accelerating, that there just are more of them, and that seems to be an accelerating phenomenon. Does that correspond to the use of executive orders and the executive branch, and what's the relationship between these two legal mechanisms?
So that's a great question. Um, Last December, we did a program at Duke Law School, and we have a symposium, the McGovern Symposium, that is named after one of our professors who died a couple of years ago, way too early, who was famous for his work in mass torts, in civil litigation, and aggregate litigation, and really trying to make the rules of civil procedure function well in the type of legal landscape that we have now. And what we were grappling with is the issue of why is it in so many instances when we have some huge national problem, opioids, maybe an oil spill, maybe an environmental disaster, maybe some product that is widely distributed and has caused harm. Why is it that they so often get thrown in the laps of a multi-district litigation judge or a class action judge to try to deal with this when they really deal with policy issues that should be within the purview of the legislative branch? We all know that there are two elected branches, the executive and the legislature, and the courts in the state systems can be elected as well, but in the federal system are appointed. But we also know that for far too long, Congress has been gridlocked. It's been at political stalemates. The margins have been very close between who's in control. And it is increasingly difficult and challenging for Congress to take on the big challenges that face our country and come up with legislation, ideally bipartisan legislation, that would come up with solutions that would be for the benefit of the entire country. So if you have Congress, which has been gridlocked and not particularly effective at undertaking the legislative initiatives that it was created to do, then you've got a vacuum. You have the executive who is to execute the law, and there's an old saying that nature abhors a vacuum. And so the executive jumps in and says, all right, Congress doesn't act. I'm going to start issuing these executive orders. I'm going to order that. And every modern president in the last 20 years has done that. It's been done by Republican presidents, it's been done that by Democratic presidents. And in a closely divided nation like we have, where pretty much on any important topic, 50% of the people believe one way and 50% believe another way, when a president puts into place their policies, there's going to be a significant portion of the country that disagrees with that. And when Congress has not answered that question by enacting legislation that governs the entire country, and the executive acts, then under those circumstances, when you have a notion where historians and people who study the presidency have said that the executives have been granting, assuming more power to act through these kinds of executive mandates in the face of a atrophied ability of Congress to be able to enact laws that govern these problems for the benefit of the whole country, that the power of the president has increased. And as the president's power increases, and as they deal in issues where other individuals feel that they have been adversely affected by a presidential policy or order, whether it was by a Democratic president or a Republican president, then you're going to have these challenges. They're going to come in, and you're going to have courts being asked to decide. And of course, I think that because of these sort of these political realities of where our country is, when the president is acting where Congress has been unable or unwilling to act, and does so in ways that may be perceived as bold. And if an individual feels that they have been adversely affected by that, then they're going to go to court and they're going to sue, and it's going to be thrown in the lap of a court to be able to decide that. And so I do think that there's a correlation between the number of these injunctions, and the consequences of those, that you could probably have a correlation. I'm not sure it's causation, but at least it's correlation between the trend for the last 20 years of an increasingly powerful executive acting through these types of executive orders and policies, because Congress has not acted itself. And the more that that happens, the more likelihood you're going to get challenges that impact whether or not it's appropriate as relief to issue a nationwide injunction. What, of course, could change that was if Congress was more successful in passing laws for the benefit of the entire country. And secondly, we could do reforms for these nationwide injunctions that would take away some of the deficiencies that we now see and recognize as being present.
Judge, if we think about what kind of reforms, you mentioned a bill that's pending and a recommendation through the administrative functions of the courts. What other types of reforms should be considered to help deal with the mischief that we're seeing with, or the perceived problems that we see with nationwide injunctions? And I guess one thing I'm thinking about is the possibility of inconsistent dueling injunctions from two or more district courts, each one exercising nationwide jurisdiction on the same issue. Are there things that we ought to be pursuing, promoting as a profession that would address these problems? Not just that one, but I'm offering that as one example.
So that's a really good question. Um, I mean, I would welcome a dialogue about what do you do with the competing nationwide injunctions, where you get one from one circuit that says no, I'm blocking it, and one from another saying no, there's no basis for blocking it. You could imagine a way in which you could do that. You could, if you had, three judge panels that were nationally selected randomly, you'd have a little bit broader basis for that, and you would lessen the likelihood that you might have that kind of result. You could also have a situation sort of like, how you handle, if you look at MDLs, let's say you've got 25,000 cases. I had an MDL that had a data security breach, and there were 380 million people whose data was compromised, and it was there were over 100 class actions and individual actions that were filed, all consolidated before me. And there was one judge in Maryland deciding cases that came from all 50 states. You could have some sort of a procedure that says that when you have one of these nationwide injunctions, assume for a moment that you had a three-judge panel that was picked randomly. It could work out that you could randomly pick three Democratic appointed judges or three Republican appointed judges, but at least they'd be dispersed. And you could say that from now on, all issues involving that political policy had to be filed before that three-judge panel, so that the same panel was considering them all. I mean, you could imagine ways that you could deal with this if we could sit down and have a thoughtful conversation about how we could limit this in a way that would permit injunctions where they're appropriate. And remember, they're supposed to be extraordinary remedies, not happening willy-nilly, but happen in a way that would avoid those, tomato competing nationwide injunctions, minimize the appearance anyway that there might be political basis for what the ruling is, and keeping inconsistent decisions from happening. So there are ways of doing that. You could also have some sort of an expedited appeal. You could say that the injunctions could only be issued by appellate courts, in which case, trial courts would not be able to have that. You'd at least have a circuit-wide basis that would make it more likely to be consistent. But there's a lot of ways of doing that if we were to sit down and focus on it. My hope is that as we move forward and we sort of try to get some dialogue and some common ground again, we're looking to generate light but not heat, that we can put some of those things on the table and try to come up with an improvement to the current situation.
Judge, as you mentioned, one of the really concerning things that we're seeing as a consequence of this nationwide injunction practice is that a single judge becomes the focus of ill will um, based on a decision, and whether that be a move for an impeachment process or something that's completely outside the law, like the threats, harassment that you mentioned. What kind of things can we be doing as lawyers, as a profession, as an organization, to to combat that? What is there for the profession to do when we've got a legal process that is focusing all of this attention on a single individual who's trying to do their job in that process?
Sure, that's a great question. So the first thing we can do is the bar, if you look at Canon 8.2 of the Federal Bar Association's model rules of professional conduct, it deals with relationships between the bar and the courts and judicial officers. And comment 3 to Canon 8.2 says that lawyers are encouraged as an ethical obligation to fulfill their traditional role of speaking out in defense of the judicial system when it's been unfairly attacked, or a judge when that judge has been unfairly attacked, because they have limits as to what they can do. That's been a cherished tradition that we have had in the bar for forever. So lawyers and bar associations are particularly well equipped to do two things. Number one, they can help reactively when there has been an unfair attack about a particular judge and a particular ruling, to reach out, write letters to the editor, contact their elected officials, and to speak out and call out an attack that crosses the line from what the Chief Justice identified as perfectly within constitutional First Amendment rights, which is informed criticism, and crosses over into one of those four areas of personal attack, threats, intimidation, threats to impeach, when you don't have the kind of misconduct that has been present in every prior impeachment of a federal judge. And I can talk about the numbers on that in just a bit because they're not very large, or calls to disregard a judicial order. So lawyers could do that. They can reach out, but they could also and should deal proactively. Speak at and lawyers have been doing this in the civic education space forever. Take advantage to give a talk to an organization on Law Day. Take an opportunity to, we have Law Day, we have First Amendment Day, we have Constitution Day, we have a number of days throughout the year when the opportunity is there. Lawyers are members of clubs, they advise businesses, they are, lawyers are members of faith communities, and they can speak to folks there. We have a whole lot of resources on our website that people can use. They've been very, very carefully curated to make sure that they are nonpartisan, that they're fair-minded, that they speak, rationally and respectfully. They don't try and take sides on any issue for which there's, legitimate debate, and help the public understand, and specifically give examples. So let me give you an example. If you hear about a situation where someone who is not an American citizen, doesn't have the greatest background, even if they don't have a felony conviction, they didn't get, civic awards for their civic awardness, and they're mistakenly deported to El Salvador, and you say to yourself, I don't really care about that. That person's not an American citizen. They're living there. They're not, maybe they had a right to live there, but they're not an American citizen. And maybe they're not a great person. So why should I care whether that person gets deported to El Salvador? And you can understand why some people would have that thought. But we as lawyers know that judicial orders that you might not agree with do lots of things. They enforce contract rights. They enforce privacy rights. They enforce compensation for someone who was injured by the fault or of another person. They protect our intellectual property. They protect our freedom of religion, our freedom of expression, and they protect us. If we get pulled over and cited for speeding or for driving while intoxicated, they protect our rights. And the minute you start saying, well, courts are not legitimate, I don't have to follow this, there's a saying that is so true when you think about it, is the rule of law depends upon the willingness of the public to comply with court orders that they don't agree with. And courts have tremendous powers, but they don't have a lot of enforcement power. They don't have militaries. They don't have the right to appropriate money, and their ability to do their job to protect all of our fundamental rights and liberties depends upon the willingness of the public to agree and to comply. And the reason why the public should do that is within the system itself, there are safeguards to protect against a wrong decision. And we've seen that in the last 100 days, where some of these nationwide injunctions have been stayed by the Supreme Court or by the appellate courts. And so we have guardrails and protections within the system itself in the event that there's an outcome that someone disagrees with that doesn't say, well, we want to pull this person off the bench and impeach him. So in the entire history of the United States, there have been only 23 times when a bill of impeachment issued by the House of Representatives by a majority vote has resulted in a trial in the Senate that resulted in a ruling on an impeachment trial. 3 times impeachments brought in against the president. None of them succeeded. 1 time against the senator, which resulted in the removal of the senator from office. 1 time for the Secretary of War, and you can tell how long ago that was because it's been the Secretary of Defense since after World War II, did not result in removal. 1 time against a Secretary of Homeland Security, which did not result in a conviction because it requires a 2/3 vote in the Senate to convict. And 15 times bills of impeachment were issued against a federal judge. And this is in the entire history of our country. Of them, 3 of the judges resigned before the hearing in the Senate. 4 times they were acquitted, and 8 times they were actually impeached by a 2/3 vote. What were they impeached for? Well, in one instance, the judge was mentally incompetent. In another instance, the judge, during the Civil War, declared war against the United States and fought for the Confederacy against the federal government. In other cases, the judges were found to have been granting favoritism in the appointment of bankruptcy trustees. In other instances, they committed perjury, or they were convicted of income tax evasion. In one instance, bribery and soliciting bribes, obstruction of justice, perjury, false statement, sexual assault on a courthouse employee. So the conduct that actually resulted in their removal from office in the entire 200+ year history of our country, and for the hundreds and hundreds and hundreds of men and women who have served as federal judges, only 8 have resulted in convictions. And when you look at the circumstances under which they have been found to be removed, of course it was something that we could agree was high crimes and misdemeanors, and never, not once, has it been based upon the fact that we think they got that decision wrong. And that's what the Chief Justice was saying in his year-end report and in his comment just a month or so ago. So we as lawyers can help the public understand that. You can go out and you can talk to people, and all the places, lawyers go to public, they go to county fairs. When I was still in practice, we used to go to the county fair of Maryland, and we had a tent right next to the 4-H club, and on the other side of the Dunk-a-Clown. And we had a mock trial with the Bar Association did. We had an actual judge there, and we had a lawyer that was on the government side, if it was a criminal case, or the plaintiff side, and a defense lawyer. And we had a hypothetical, and we tried a case. We had witnesses who would come in, and you'd see 20 or 30 people would come in there with their cotton candy and their popcorn, and they would sit there and they would watch that for a while. So we engage with the public. We know how to do that. We represent businesses. We can talk to their businesses. We can talk to Kiwanis clubs and the 4-H club, and we can talk to scout troops. We can invite them into the courthouse. We can go into the schools. We can write letters to the editor. We can do all those things. And we are natural communicators. We're advocates. We're persuasive. And when we do that, we broaden the base of members of our community. There was a recent poll that was done that showed that 75% of the adult population in the United States couldn't identify the three separate branches of government. How many justices there were on the Supreme Court? What checks and balances meant? What separation of powers meant? They couldn't identify that. They just didn't know. You combine that with the fact that the National Center for States Courts does a survey of public perception of the state courts every year. 2022, the polling company that did that report prefaced its findings with this caution to the National Center for State Courts. It said, to understand the data that we have here, you've got to appreciate that the overwhelming majority of the United States public has never, ever had any encounter with the legal system whatsoever, and virtually never gives it any thought on a day-to-day basis. So you start with the fact that we have a population largely unaware of what we do and why. Combine that with the fact that where do they get information about judges? Well, when was the last time in a TV show or a movie or a novel that a judge was a character where the judge wasn't corrupt or a drunk or a tyrant or a senile doddering fool? You don't see the judges, like I did. I worked 7 days a week for 26 years, and I felt like I was working like a rented mule, and I felt that the public had a right for me to work that hard. But you
Judge,
don't see that.
I definitely very much agree about how judges and lawyers are portrayed in fiction. And I feel like there might be another whole education program on that alone, which will be a lot of fun.
Yeah,
Let's pause here for Alicia to give us the code, and then I'd like to take the little bit of time we have left and see if we can field some questions.
sure.
The code on the screen is MDL, spelled M for Mike, D for Delta, L for Lima. Again, the code on the screen is MDL, spelled M for Mike, D for Delta, L for Lima.
Great. Now, I think some questions or comments have gone into the chat, although I don't see it right now. But can I ask if anybody would want to come to unmute and ask a question? Please jump in. Raise your hand, turn on your camera and your mic.
It's like when I teach a class, none of the students
All
want to
right.
answer questions.
They weren't, well, maybe the questions have all gone into
I think
gone into
Anna.
the chat.
Brian, it's Anna Marie. I'm gonna
Hi, Anna Marie.
ask about the elephant in the room. What do you do when the executive branch is complaining about the quality, is suggesting impeachment of judges who disagree with him, just for an easy piece?
So yeah, the question's a good question. When the chief executive of the United States is saying we should impeach this person, how do you deal with that? And the Chief Justice had said what the Chief Justice said. We as lawyers and judges and former judges can certainly reference what the Chief Justice said. We can engage with the press. We can try to write letters to the editors. But the truth of the matter is that Teddy Roosevelt talked about the bully pulpit and the ability of the president to say things that were going to be carried nationwide. The truth of the matter is that there's asymmetrical ability to converse with the public. When the president or a prominent elected official says something, when someone who let's just take a hypothetical, owns a social media platform that has hundreds of millions of people that sign on, and they go on to that platform and make an accusation, then you've got, in terms of quality and quantity of what that message that is the attack message is, that has to be responded to. And you have to respond. You have to try to, Marshall McLuhan is the Canadian communications expert of the 70s who said that the medium is the message. So to Ms. Richmond's point, I would say we need to figure out how we as a bar can, again, generate light but not heat, but get it to the platforms that get it out as broadly as some of those people who are attacking are doing. And to a certain extent, we're never going to have that same bully pulpit. And if you've got a highly placed individual whose words will be repeated throughout the blogosphere and on national TV and in every headline in the country, and they say things, a message that is that there's one that needs to be responded to, then you're going to have a asymmetrical challenge to try to respond to that. Does that make it a challenge? Absolutely. But the alternative of doing nothing is not acceptable. And we all just have to try to engage with our local communities from the ground up and try and have a dialogue that's ongoing and not just simply responding to one particular attack, but an ongoing dialogue to help build appreciation and hopefully respect and trust, rebuild it within the public.
Okay, Judge, we've reached our time, and I'd be happy to talk with you about this all afternoon. I can't get enough of it, and there's a lot of things that we haven't touched on. Anybody, if you want to hang around for a few minutes and chat, you're welcome to. I'll stick in here, but we should officially wrap up the program, and I'll do that by just thanking you, Judge, again for taking the time to be here, for everything that you're doing in the public sphere to educate us all on these issues and to provide leadership and to provide a voice that's from within the judiciary, but isn't restricted by the rules that prevent judges usually from speaking out on these things directly. Thank you very much.
Well, I thank you for the honor of being able to visit with you. You have a terrific organization. I'd look forward to coming back at some time with another topic if you wanted, but I'll stick around for a few more minutes. I have a call at 4, but I have some time between now and then. If there's anybody who's a diehard that I haven't put to sleep already that wants to stick around for a few more minutes, I'm happy to answer a couple more questions if that would be helpful.
Right. Alicia, anything else we need to do to officially wrap up our program?
Nope, we are all set. All of the links and everything you need should be in the chat. But again, feel free to reach out to me anytime with questions. Anna Marie, did you want to add anything to your questions? Because you did have a little bit more in the chat.
I think she's gone, Alicia.
Oh. Judge, I don't know if you saw, and I confess, it's sitting here, but I haven't had a chance to read it yet. But there was a decision issued by the district judge in the Perkins Cowie law firm in executive order case just in the last. Well, what's the date on it? I guess it was.
I think it
was Friday.
It was Friday. Yeah.
Mm-hmm.
Judge Howell.
In that case, the two. I guess I'd wonder two things. Is how common is it for the district court to go right to final injunction, as that judge did? And again, I'm saying I have not read the whole thing, but I know that much about it. And two, have we seen any personal targeting of that judge, in the first 72 hours from issuing that decision?
As for how unusual is it? First of all, the executive order itself was pretty unusual. I don't think in my entire lifetime I've ever seen an executive order like that. And the nature of what it was so, it was described in a 100+ page opinion by Judge Howell as being, blatantly vindictive and to bring retribution. She identified specific constitutional rights that were violated by that. She talked about how the government's justification for doing that was completely unsupported by existing law or any law that could in good faith be argued. It came across as a final decision in the case because it was a motion for summary judgment. So it was a final judgment in that regard. So it would be unusual. You could not, in fact, you could not issue a final injunction without finally resolving the case. So what happened was it was filed. She may have issued a TRO, which can only last for 14 days unless it's renewed once. That could have led to a preliminary injunction. And then when she granted summary judgment, and as part of the relief issued a permanent injunction, setting forth her reasons for that. Now, it was not a surprise as to what her ruling was, because during arguments, the justification that the government gave was, had they come in and said the dog ate my homework, I think she probably would have found that to be, a more plausible explanation. But she did not find that the explanation given by the Justice Department was a legitimate basis for the policy. She called it out for what she thought it was, and therefore issued it to end it and to make it a permanent injunction and voiding the executive order. Have there been attacks against her? Sadly, I don't know of any, but I in this environment would be surprised if there have not been. There are a number of other judges on that same court who have been subject to some of these attacks. Hopefully, the Marshal Service is able to monitor them and to provide her with safety and security in the event that occurs. But among those of us who are on this call, remaining on this call, have any of you ever seen any kind of an order that targeted a law firm like that for representing a client? I mean, can you imagine what would have happened to John Adams when he defended those redcoats in Boston back then? I mean, that's been held up as an example of a lawyer doing the most, challenging and difficult things that we call out and we say, this is what we as lawyers are expected to have the courage to do when we support and defend the Constitution. When someone has speech that you disagree with, the First Amendment is supposed to protect that speech, not put a target crosshairs on your forehead for retribution, by a private law firm, by an organ of the government. And that's something I think that the unprecedented nature of those executive orders and the defenses that were raised were such that I think the judge felt that under the record before the judge, there was no genuine dispute of material fact, and that as a matter of law, the plaintiffs were entitled to judgment, and she issued a permanent injunction. Now, full disclosure, I was one of the 320 plus retired judges that signed on the amicus brief that supported the motion for summary judgment.
Judge, I'm happy to say that this organization signed one of the amicus briefs in that case as well.
I'm not surprised. So listen, thank you so much for what you're doing. Let's stay in touch. You can follow along. Everything we do, we put on our website. We want it to be available. All these programs, all these modules are available for anybody. We'll let anybody use them. We have advice as to how you can do it based on our experience. We're going to expand it, I think, in the next year with some additional programming. We are simply trying to convene and share. We have a spreadsheet on our Defending the Judiciary page that has probably close to 100 examples of various editorials or responses or orders or things of that nature. We have links to various orders issued by judges. And we will periodically have more of these calls. On the last call, I think that the bar for the county of New York County were on there, and we had the city bar as well. Happy to make sure that when we do it in the future that we reach out to the Bar Association of Erie, because you guys have been great. But we can do this collectively together, and we can do it in a way, Winston Churchill said that tact was the ability to tell someone to go to hell in a way they could look forward to the trip. And we lawyers are very good at getting points across in a way that can generate light but not heat. And I would welcome the opportunity to continue to work with you in that direction. So thank you so much for sponsoring this and putting up with me. And I wish you all well, and hope to be able to be engaged with you guys in the future.
Judge, I look very much forward to that. Thank you.
Bye-bye, everyone.
Take care. Bye-bye.